I'd like to talk with you for a few minutes today about the Pregnant Workers Fairness Act, the PWFA, which became federal law on June 27, 2023, and about the EEOC's recent proposed regulations to implement the new law. The PWFA was passed by Congress for the important purpose of addressing gaps in existing coverage under Title VII, the Americans with Disabilities Act, and the Family and Medical Leave Act for workers affected by pregnancy, childbirth, or related medical conditions, with the goal of keeping those employees healthy and on the job. The PWFA is modeled after and operates much like the ADA that most of you are very familiar with a few key differences. The PWFA requires covered employers, that means those with 15 or more employees, to provide reasonable accommodations absent undue hardship to a qualified employee with known limitations related to pregnancy, childbirth, or related medical conditions. The PWFA's coverage is intentionally broad. The term related medical conditions includes current, past, and potential pregnancy, lactation, use of birth control, infertility treatments, and endometriosis. So let's go through a few of the key definitions under the proposed regulations. For starters, who is a qualified worker under the PWFA? So consistent with the ADA, a qualified worker means an individual who, with or without reasonable accommodation, can perform the essential functions of the job. But the PWFA also includes, as a qualified individual, individuals who are unable to perform an essential function of the job temporarily, if that employee will be able to perform the essential function in the near future, and the inability to perform the essential function can otherwise be accommodated by the employer. In the near future is defined under the proposed regulations as generally up to 40 weeks from the start of the temporary suspension of an essential function. So next, what is a known limitation under the PWFA? The term limitation includes both physical and mental conditions known to the employer, even those that may be modest, minor, or episodic. In other words, to be covered by the PWFA, the employee's physical or mental condition does not need to rise to the seriousness of a disability under the ADA. What accommodations are employers required to make under the PWFA? So like the ADA, the PWFA requires covered employers to provide reasonable accommodations absent undue hardship. The proposed regulations include a non-exhaustive list of examples of possible accommodations, including job restructuring, part-time modified work schedules, assignment of light duty, more frequent breaks, changes in performance or production standards, telework, permitting the use of paid or unpaid leave, and temporary suspension of one or more essential functions of the job. The proposed regulations also note that simple accommodations for pregnancy will, in virtually all situations, be viewed as reasonable and not imposing an undue hardship when requested by the employee. Those include to carry water and drink as needed in the employee's work area, to take additional restroom breaks, and to take breaks as needed to eat and drink. So how is undue hardship defined by the PWFA regulations? Undue hardship is consistent with the ADA and is defined as necessitating significant difficulty or expense on the part of the employer, considering a number of factors, including the length of time the employee will be unable to perform the essential functions of the job. How does the PWFA fit with state and local laws? The PWFA is similar to existing laws in a number of states. For Virginia employers, the state law comparable to the PWFA is the Virginia Values Act, which provides that no employer shall refuse to make reasonable accommodation to the known limitations of a person related to pregnancy, childbirth, or related medical conditions, unless the employer can demonstrate that the accommodation would impose an undue hardship on the employer. The EEOC's proposed regulations for the PWFA will remain open for public comment through October 10, 2023. The PWFA requires the EEOC to finalize and issue regulations by no later than December 29, 2023. Employers should be aware, however, that the PWFA is currently the law of the land, and the EEOC has already begun accepting charges under the PWFA for incidents alleged to have occurred on June 27, 2023 or after.